You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Email marketing remains one of the most common digital outreach strategies, but it is governed in the United States by the Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003, commonly called CAN-SPAM. This law was enacted to combat the flood of unwanted and deceptive commercial email that had begun overwhelming inboxes in the early days of digital commerce. CAN-SPAM applies to all commercial electronic mail messages, which are those with the primary purpose of advertising or promoting a product or service. Unlike some global frameworks, CAN-SPAM does not require prior consent before sending marketing emails, but it does establish strict requirements for identification, truthful content, and honoring opt-outs. For learners, this reflects the American approach to marketing regulation, focusing less on opt-in models and more on ensuring transparency, accountability, and consumer choice through clear rules about how emails must be constructed and managed. The law distinguishes between commercial content and transactional or relationship content. Commercial content promotes products or services, while transactional content provides information related to an existing relationship, such as receipts, warranty notices, or account updates. This distinction matters because purely transactional messages are exempt from many of CAN-SPAM's requirements, though mixed messages must still comply when the commercial content is deemed primary. For learners, this shows how intent shapes compliance. A receipt email that subtly includes a marketing offer may shift categories, triggering obligations. Organizations must carefully evaluate the purpose and design of each message to ensure proper classification and compliance. CAN-SPAM also clarifies who is responsible for compliance. The sender is defined as the entity whose product or service is promoted, and in multi-branded or co-branded messages, multiple sender rules may apply. This prevents companies from shifting responsibility onto email service providers or marketing partners. For learners, this reinforces the principle of accountability. The brand benefiting from the message cannot disclaim compliance simply because another party pressed send. Shared campaigns require clear allocation of duties to ensure at least one sender meets all statutory requirements, while others avoid conflicting practices. Technical accuracy is emphasized through header integrity rules. From, to, and reply to fields must accurately reflect the sender's identity, and subject lines may not be deceptive or misleading. For learners, these requirements reflect how easily consumers can be manipulated in digital communications. A misleading subject line promising, quote, urgent account information that actually contains a sales pitch is not only unethical but illegal under CAN-SPAM. Authenticity in headers ensures that recipients can make informed decisions about whether to engage with the message. CAN-SPAM requires commercial emails to be identified as advertisements unless the recipient has provided prior affirmative consent. Identification may be explicit through labeling, though the law permits flexibility in design. For learners, this provision demonstrates the emphasis on truthfulness rather than rigid formality. As long as the message clearly communicates its promotional nature, compliance is achieved. Consent, however, can shift this requirement by making advertising expected in the context of an established relationship. Every commercial email must include a valid physical postal address for the sender. This requirement grounds digital communication in tangible accountability, making it harder for fraudulent actors to hide. For learners, this detail underscores the principle of traceability. An address provides recipients and regulators a means to locate and contact the sender, deterring anonymous mass spam campaigns. Opt-out mechanisms are among the most important protections under CAN-SPAM. Every commercial email must include a clear and conspicuous method to unsubscribe, such as a link or reply function. Opt-out requests must be honored within 10 business days, and organizations cannot charge fees, require personal information beyond an email address, or impose burdensome steps to unsubscribe. For learners, this highlights consumer control as the centerpiece of the law. Opt-outs empower individuals to regulate their inboxes, and compliance hinges on making the process simple, free, and effective. The law also prohibits abusive practices such as harvesting email addresses from websites, using dictionary attacks to guess addresses, or routing messages through unauthorized relays. For learners, these prohibitions target the tactics of spammers who exploit technical vulnerabilities to flood networks with unwanted mail. By criminalizing such activities, CAN-SPAM reinforces that compliance is about both conduct and content. Third-party email service providers play an important role, but brands must oversee their vendors carefully. Contracts and monitoring ensure that providers follow CAN-SPAM requirements on consent, suppression lists, and disclosure. For learners, this illustrates how vendor management aligns with compliance themes across privacy laws. Outsourcing execution does not outsource responsibility, making oversight a core element of lawful campaigns. Affiliate and partner programs also require attention. When companies share email lists or allow affiliates to send messages on their behalf, they must ensure compliance with suppression list use, truthful identity, and opt-out procedures. For learners, this shows how marketing ecosystems multiply risks. Affiliates may operate outside formal structures, but regulators hold brands accountable for their agents' actions, making governance and monitoring essential. Suppression list hygiene is another practical requirement. Once consumers opt out, their addresses must be stored securely in suppression lists to prevent further outreach. These lists may only be used internally for compliance purposes and cannot be shared for marketing. For learners, this highlights the importance of respecting negative consent. Even data that signals disinterest carries obligations and must be handled with security and discipline. Record-keeping supports CAN-SPAM compliance. Organizations should maintain records of consents, suppression lists, vendor contracts, and message templates to demonstrate adherence in audits or investigations. For learners, record-keeping reflects the principle that compliance is provable, not presumed. Documentation ensures organizations can respond effectively to inquiries and avoid liability for inadvertent lapses. Enforcement authority lies with the Federal Trade Commission, which may impose civil penalties, seek injunctive relief, or coordinate with state attorneys general. Violations can result in significant fines, and criminal liability may apply in cases of aggravated offenses like harvesting. For learners, this highlights that email marketing regulation is not symbolic. It is actively enforced, with both federal and state actors participating to hold violators accountable. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The Junk Fax Prevention Act of 2005, or JFPA, was enacted to curb the practice of sending unsolicited advertisements by facsimile, a problem that at its peak created significant costs for businesses and consumers alike. Unlike email spam, fax spam imposes direct expenses on recipients by consuming paper, toner, and device availability. The JFPA defines an unsolicited advertisement as any material that promotes the commercial availability or quality of property, goods, or services transmitted without prior permission or an applicable exception. Covered equipment includes traditional fax machines, as well as multifunction devices and online fax services that serve the same function. For learners, this definition underscores the statute's intent, protecting recipients from both the economic and practical burdens of junk faxes, while still permitting legitimate business communications under clearly delineated conditions. A central feature of the JFPA is the Established Business Relationship, or EBR, exception. This allows businesses to send fax advertisements to recipients with whom they have an existing relationship, provided the number was voluntarily provided in the context of that relationship and the recipient has not opted out. However, the scope of the EBR is limited and must be carefully documented to withstand scrutiny. An EBR does not create a blanket license to send unlimited advertising, but instead provides a narrow pathway for continuing communication with customers. For learners, this shows how the law balances consumer protection with business practicality. By limiting faxes to those who have some expectation of communication, Congress ensured that the statute did not unduly burden legitimate customer engagement. Another key compliance pathway is obtaining prior express invitation or permission, which serves as an alternative to relying on an EBR. This permission may be secured in writing, electronically, or orally, but institutions must maintain records demonstrating that consent was knowingly given. The standard is explicit. Recipients must clearly understand that by providing a number, they are agreeing to receive advertising faxes. For learners, this highlights the centrality of consent in privacy frameworks. Without proof of express permission, a sender risks liability for every fax transmitted, underscoring why organizations must implement robust consent capture and documentation processes to validate their outreach practices. The JFPA also requires that all fax advertisements include a mandatory opt-out notice, placed clearly and conspicuously on the first page. This notice must explain how recipients may request to stop future faxes and must include a cost-free mechanism for doing so, such as a toll-free phone number, fax number, or website address. The opt-out channel must be available 24 hours a day, 7 days a week, and requests must be honored promptly. For learners, these requirements emphasize operational discipline. Providing an opt-out is not enough. It must be simple, continuous, and reliable, ensuring that consumers retain meaningful control over how their fax numbers are used for marketing purposes. Identification and transparency requirements complement the opt-out provisions. Fax advertisements must include clear sender identification, valid contact details, and a date-time imprint generated by the sending equipment. These requirements enable recipients to determine who is contacting them and provide regulators with audit trails for enforcement. For learners, this reinforces a recurring theme across marketing laws: anonymity erodes trust. Just as canned spam requires accurate headers, the JFPA ensures that recipients know who is responsible for a communication and how to contact them, fostering accountability and discouraging deceptive or fraudulent practices in fax marketing. Publicly available fax numbers introduce additional compliance challenges. Businesses may assume that numbers published on websites or directories are fair game, but the JFPA clarifies that availability does not equal consent. Senders must either demonstrate an EBR or secure prior express permission before transmitting faxes, regardless of whether numbers are easily found online. For learners, this nuance illustrates a common compliance trap. Organizations must avoid conflating accessibility with authorization. Maintaining documented evidence of consent or relationships is essential, as regulators and courts consistently reject the argument that public posting constitutes implied permission for advertising contact. Liability under the JFPA extends not only to advertisers, but also to fax broadcasters that transmit messages on their behalf. While broadcasters may argue that they are merely conduits, the law imposes shared accountability. Advertisers are primarily responsible, but broadcasters may face penalties if they demonstrate a high degree of involvement or fail to implement safeguards against illegal transmissions. For learners, this concept of vicarious liability reinforces the idea that compliance must be shared across the ecosystem. Outsourcing transmission does not absolve a company of responsibility. Instead, it creates an added obligation to monitor partners and enforce compliance through contracts and oversight. Record-keeping is a vital element of JFPA compliance. Organizations must retain evidence of EBRs, prior express permissions, and opt-out processing to defend against complaints or litigation. This documentation provides proof that faxes were sent lawfully and that consumer requests were respected. For learners, record-keeping illustrates the operational backbone of compliance. Without accessible and organized records, even legitimate practices may appear unlawful to regulators or courts. Institutions must therefore treat documentation as both a defensive shield and a proactive tool for continuous compliance assurance. The JFPA applies not only to traditional fax machines, but also to online fax services and digital equivalents. Courts and regulators have clarified that functional equivalence, not the form of delivery, determines coverage. As a result, internet-based faxing platforms must also comply with opt-out, identification, and consent requirements. For learners, this demonstrates how statutes adapt to technological evolution. The underlying principles of fairness, consent, and consumer protection apply, regardless of whether a message travels over telephone lines or through digital platforms that replicate fax functionality. Safe harbor provisions provide limited protection for senders who can demonstrate good faith compliance efforts. For example, if an organization had a reasonable basis for believing it had an EBR or valid permission and maintained functioning opt-out processes, regulators may exercise discretion. However, safe harbors are not blanket immunities. For learners, this illustrates how compliance frameworks reward diligence but punish complacency. Organizations that actively maintain programs, train staff, and respond promptly to opt-outs reduce their exposure, while those that neglect these obligations face heightened liability. The Federal Communications Commission oversees JFPA implementation, and its rules often interact with state-level fax advertising laws. Some states impose stricter requirements, such as shorter opt-out response timelines or enhanced damages. For learners, this highlights the layered nature of compliance in the United States. Federal standards provide a baseline, but organizations must also monitor and adjust practices to meet more stringent state laws, ensuring they respect the highest applicable protections. Private rights of action make the JFPA particularly risky. Consumers and businesses that receive unlawful faxes can sue for statutory damages of $500 per violation, with treble damages available for willful or knowing violations. Given the volume-based nature of fax campaigns, these damages can aggregate into substantial class action exposure. For learners, this underscores the high stakes of compliance. Even a small misstep repeated across hundreds of transmissions can result in significant liability, reinforcing the importance of disciplined governance. A compliant fax marketing program requires governance elements such as clear consent capture, reliable opt-out processing, secure record retention, vendor oversight, and regular compliance reviews. Institutions must view compliance as a continuous process rather than a one-time setup, adjusting to evolving technologies and legal interpretations. For learners, this programmatic approach mirrors trends in other privacy laws. Sustainable compliance depends on embedding privacy principles into every stage of operations, ensuring that marketing practices respect both the letter and the spirit of the law. In conclusion, the JFPA complements CAN-SPAM by addressing another channel of marketing communications with direct cost implications for consumers. Together, these statutes emphasize truthful identity, robust opt-out mechanisms, documented permissions, and disciplined vendor oversight. For learners, the synthesis is clear. Whether through email or fax, compliance frameworks prioritize honesty, consent, and consumer control. Effective programs align technical practices, contracts, and governance structures to ensure marketing outreach builds trust rather than eroding it through intrusive or unlawful tactics. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.